morning. Good afternoon, everyone. Thank you very much for attending this webinar. Thank you, Kaylee, and to the Chamber for allowing us to present it. There are many costs and expenses which go along with owning real property. These can be a burden, especially during these particular times that we are living in. However, in New Jersey, these do not necessarily have to be a fixed expense, property taxes. You may be able to reduce those taxes if in fact you are overassessed. We have a system in New Jersey which allows you to file an appeal to have your property taxes reduced. However, that system comes with many pitfalls, deadlines, rules. You may have a tremendous argument that your property taxes should be reduced. You may be horribly overassessed. And yet, because you fall into one of these pitfalls or miss one of the rules or one of the deadlines, you don't get relief for that tax year. So what Rich and I hope to do today is to kind of give you a little primer in how to avoid some of these pitfalls, how to analyze your assessment to determine whether you may be entitled to some relief on your property taxes if you are overassessed. And we're going to go through some of the things that you need to do. We're going to talk about how you analyze the assessment and the application of Chapter 123, and we'll explain to you what that is. The procedures and deadlines which exist in a property tax appeal. Valuation issues generally. The impact of COVID-19 on value. Certainly a big topic the last year and this year as we get into 2021. And we're still feeling the effects of COVID-19 on the market, and remote trials and other proceedings, and how COVID-19 has impacted the way tax appeals are being handled, both at the county tax board level as well as at the tax court level. Okay, analyzing the assessment and the application of Chapter 123. In New Jersey, all property is assessed at its fair market value as of the assessing date. The assessing date is October 1st of the year before you are looking at reducing the taxes or looking at the assessment. So for 2021, the assessing date was October 1st of 2020. When we say that the property is to be assessed at its fair market value, if the property is worth $1 million, for example, then it should be assessed at $1 million. However, what happens in New Jersey fairly frequently is that unless a municipality is reassessed every year and the properties are at 100%, the assessments often remain the same between revaluations. General revaluations may take 5 years, 10 years, or more. We've had municipalities that haven't had revaluations in 30, 40 years. So what happens is that assessment and its relationship to the fair market value of the actual property that's being assessed tends to slip away from 100%. So in New Jersey, they have devised a system whereby there is a ratio. It's called Chapter 123, and it's devised every year for every municipality in the state by the Division of Taxation. The way it works is that all of the usable sales are sent down by the tax assessor. The tax assessor gets copies of all of the sales which take place in the assessor's municipality. Some are disqualified because they're not necessarily fair market value sales. Common ones are sales between father and son, mother and daughter, estate sales, things like that. But so the assessor will weed those out, take the good sales that are actual fair market value sales, and send them down to Trenton, to the Division of Taxation. They are plugged into a formula, and then the state will come up with a Chapter 123 ratio for that municipality for that year. Now, the law recognizes Chapter 123. It's called Chapter 123 because that's the designation it was given when the statute was enacted. It includes a 15% corridor or common level range up or down, because the law recognizes that the assessor can't get every property at exactly the ratio. For example, if the formula shows that the property, the ratio is 75% for that municipality in that year, it's impossible for the assessor to get every property at exactly 75% of its value. So the assessor is allowed a 15% corridor up or down, and as long as the assessment comes within 15% of that ratio, and the value comes within 15% of that ratio, then the assessment will be upheld. Now, Chapter 123 does not apply when there has been a municipal-wide revaluation or reassessment in the municipality. And we're seeing more and more municipalities do that, by the way, because technology now is enabling that to be done a little bit easier. But so if there has been a revaluation or reassessment, the Chapter 123 ratio is automatically 100%, or the value, the ratio to the assessed value is automatically 100%. And it can never go above 100%. If you look at the tables that are published for the Chapter 123 ratios by the Division of Taxation, and we'll get into how you can get those in a minute, you might see that the ratio, because of the way the math works out, is 110%. Doesn't mean you get to be assessed at 100%, 110%. You can only be assessed at 100% value from year to year. Right, so assessments are not always what they seem. This is how this works. So you may have a property in Morris Township, and you may have a property in East Hanover, and both properties may be worth $1 million. Now you get your notice of assessment card, and that's going to come out around February 1st every year. So they're about to be mailed out for 2021, right around February 1st. And you get your card in Morris Township, it says $1 million, and you get your card in East Hanover, and it says $1 million. And you may say to yourself, well, I don't have an appeal in either town. I just bought each property for $1 million. However, that is not the case. If Morris Township's ratio is 100%, so at $1 million, the assessment is fine. East Hanover's ratio, however, is not 100%. If you apply the ratio and divide the ratio by the assessment, it's really working out to be the value of $1,353,000. And since you just purchased it for $1 million in an arm's length sale, in East Hanover, you are overassessed. And here's how that works. In Morris Township, the ratio is actually 93.92%, but the upper limit, and we mentioned that 15% corridor, the upper limit's 100%. So therefore, that $1 million assessment based on the $1 million sale price is fine. You're not going to be able to win an appeal because you have to demonstrate the market value is less than the assessed value. However, in East Hanover, the ratio is 73.91%. So that results in an equalized value or implied market value of $1,353,000. So in order to be successful in an appeal, you must demonstrate that the market value is below the equalized value. That would seem to be fairly simple here because the ratio works out to $1,353,000 and you just bought it for $1 million. However, there is one other factor you must consider, and that is that there is an upper limit involved. Remember that 15% corridor. So at a 73.91% ratio, 15% of that upper limit would be 85%. So 15% of 73.91% would be 85%. So if you take the assessment of $1 million divided by the 85%, you would have to show the property has a value less than $1,176,500. Since it's sold for $1 million, you would fall outside of that ratio and you would have an appeal. Simplest way to look at this is you take your assessment, you look at what not only what the Chapter 123 ratio is, but what the upper limit is. You divide the assessment by the upper limit, and that will give you the value that you must show the property is worth less than in order to get relief. So that's a simple equation. Just take the upper limit, divide it by the assessment, and that is the value that you must prove the property is worth less than in order to get a reduced assessment. And of course, if you get a reduced assessment, then you're going to save on your property tax because the tax is computed based on two factors. One is the tax rate, and then the other is the tax assessment. So if you get the assessment reduced, your taxes will be reduced for that year. Another thing to remember is the ratio, the upper limit also can never go over 100%. So if the math will sometimes work out that the upper limit is 110%, 108%. You don't divide the assessment by 108%. It's always just 100%. You can never be assessed in New Jersey at a value that's greater than its actual market value. And this is just an example of the tables here from Morris County. and it shows you what the ratios were for each municipality for this particular year. Again, if you go on the Division of Taxation website, you will be able to download or just click on and get the ratios that are in effect for every municipality in the state of New Jersey for that year. And it's a very great resource, doesn't cost anything. And it's a good tool to use if you want to analyze how you're going to come up with your assessed value and whether or not you should file an appeal. All right, reverse appeals. It's a two-way street in New Jersey. First off, if you file an appeal on your own and you say, my property is overassessed and I want a reduction, the municipality may file what's called a counterclaim and argue to the court or to the board that the property not only is not worth what it's assessed for, it's actually underassessed. It should be assessed for more because the property's value is actually more. So, so that is always a possibility in any tax appeal that you may file. The reason that's important is if a municipality files a counterclaim and you have filed an appeal, and now you get into looking at your appeal as you go forward and you begin to prosecute it before the court, maybe you talk to an appraiser and you realize, wow, what did I file this appeal for? I am underassessed. I am going to get an increase. Okay, I withdraw my appeal. I'm going to go away now and everything is fine. Well, if there's no counterclaim, you can do that. If there's no counterclaim, you can withdraw your appeal anytime up until the close of proofs in a trial before the tax court. However, if the municipality has filed a counterclaim, and you try and withdraw your appeal, the municipality is always free to say, not so fast. We have filed a counterclaim. We also think it's underassessed, and we're going to go ahead with our counterclaim, and we're going to try and get the assessment increased. Now, the municipality has the burden of proof, just as you have the burden of proof in your appeal. Whoever files the appeal has the burden of proof of proving that the assessment is incorrect. But it is that is something to bear in mind. No matter even when you file an appeal as a taxpayer, you may have an argument. And by the way, a taxpayer is any entity that pays the real estate taxes on the property. It can be the owner, it could be the tenant if the tenant pays the taxes. It may be the mortgage holder if the mortgage holder is actually paying the taxes. So it's any entity that is actually paying the taxes on the property.
Tom, if I could just jump in first.
Yeah, go ahead, Rich.
The prospect of a counterclaim highlights the importance of if you believe you're overassessed and you speak with either a lawyer or perhaps an appraiser who does real estate tax appeal work. If you're a corporation, an LLC, you will need a lawyer to file the appeal. That's what the rules provide. But whoever you speak with first, you should expect them to do at least an initial analysis. One of the things we do is we spend a lot of time with potential clients before we get retained to see if the case is ripe for an appeal. We want to make sure, one, that you're not in line for an increase. And I've had people call where they had purchased a property fairly recently, and the assessment was well below what they paid for the property, and put them in danger of an increase. So, we don't want to take that case, certainly, for a couple of reasons. It's certainly bad business, and we could be on the hook for potential malpractice. So, same thing with an appraiser. You shouldn't be spending money for a full-blown trial-ready appraisal report until you've at least had an initial analysis to determine whether an appeal is warranted. And we spend a lot of time with potential clients before we even sign them up to see if a case is worthwhile. I'm going to talk a little later about how you value a commercial property, because it's a little more complicated than just looking, at potentially the sales comparison analysis, because commercial properties don't really sell as often as single family homes. So there's a limited market. So there's a different way the court will value those. But again, it's important to have that review up front before you take the next step of hiring lawyers and appraisers to prosecute an appeal for you. You want to make sure you're not in line for an increase.
That's correct. And another important factor while we're on this particular topic is that the only issue when you file an appeal before the court or the board is the value of your property. It doesn't matter what your neighbors may be assessed at. Very often, I know Rich and I will get a call. Well, my property is 100% ratio. My property is assessed at $400,000. Well, good. When did you buy it? I bought it October 1st of last year. Great. That's the assessing date. How much did you pay? $500,000. Well, I don't think you have a case. Yeah, but my neighbor, he lives next door. He's got an extra bedroom. He's got a pool. Boy, you should see the landscaping on his property. And he's assessed less than me. That is not a valid argument. The only question is, what is your property worth? The way the law looks at it is, just because your neighbor may be assessed incorrectly doesn't mean you get to be assessed incorrectly. Your remedy would be to file an appeal to increase your neighbor's assessment. I've been doing this for 38 years, and I've only ever been involved in one instance where I saw that happen. I don't know if Rich has seen it at all, but Rich, have you ever seen it?
I have never seen it, and it's often the out to get off the phone with somebody who is just irate over their tax bill. I'm dealing with a gentleman now who paid $1.8 million for a property that was completed last year, a residential property. It's in another county. He received his added assessment. We won't get into the detail of that too much, but essentially, if you're assessed at X and you improve the property and you increase the value, the municipality can increase your assessment for that year for that portion of the property, for that increased value of the property. And he was really upset by that. But the new value was well below what he paid. So I said, look, I'm not going to take the appeal for you. And he insisted. He was so irate over the amount of taxes he was going to pay. I said, the way we typically work on tax appeals is on a contingent fee basis where we get a percentage of the tax savings. So there, I know I'm not going to earn a fee. And the other way a lawyer would bill is on an hourly basis. And I wouldn't take his money. And I say that to people all the time. I just heard from this gentleman again, because the assessment this year has gone up even further, but it is still well below what he paid for it in the early part of 2020. There's no case. And that is a word of caution when you're looking at property to purchase. Understanding what the assessment is at the time you're looking to purchase a property is critical, because as we talked about a few moments ago, as Tom talked about, the assessment doesn't necessarily tell the full story. And you can look at the tax bill and you understand what your taxes are going in, but if you're paying $2 million for a property that's assessed at $1 million, you might have a problem down the road in terms of an increased tax liability. And Tom's going to talk about reverse appeals, which we're seeing more and more in New Jersey these days. So I'll turn it back to Tom.
Okay. Yeah, we're actually seeing, before I get into reverse appeals, another phenomenon we're seeing in the last few years is that there have been a lot of properties that are purchased and then rehabilitated by the purchaser. Now, oftentimes those properties are somewhat run down, so they're then purchased by the rehabilitator. Extensive work is done on them where they may be gutted down to the studs. You may see new kitchens, new baths. That will always trigger a new assessment, because now under the added assessment law and under the assessing laws in general, the assessor can increase the property assessment. And I've had a few people call me shocked about that, because they factored into their equation that it was worth buying it and putting all that money into rehab it, provided my taxes weren't going to be increased or weren't going to be increased that much. And they are increased, and they may be increased a lot, and there may be nothing you can do about it because the value is there. So that's also something to be aware of. Reverse appeals. What we're starting to see a lot more and more of is appeals by municipalities themselves to seek an increase in the value of a property. Mostly it's in the larger cities, such as Newark, Elizabeth, and Jersey City. It's mostly dealing with commercial properties and industrial properties. We're not really seeing it on residences. They're not filing appeals to increase people's homes for the most part. But certainly properties that are major industrial and commercial and retail properties, we're seeing appeals. Maybe not so much retail now because the value is not there, but what we're seeing is that properties are selling, and when the market was good, especially pre-COVID, and you had these large sales and the assessments may not have been increased because there hadn't been a reval, now the municipalities are actually filing appeals to increase. And there have been some recent court decisions that have upheld that action. So that's also something. And the way that it works is the 15% cushion can work the other way, which establishes the lower limit. So in our East Hanover example, property was assessed at $1 million. And we talked about the upper limit and how you figure that out. Well, the lower limit is 62.82%. So if you take the $1 million and divide it by the 62.82%, if the municipality can show the property is worth more than $1,591,800, the property will assessment can be increased. And we're seeing more and more appeals, affirmative appeals filed by the municipalities to do just that. Again, mostly with the industrial and commercial. So that's also something to be aware of. And if that happens, you can defend it. You certainly have the right to argue and submit proofs that and again, it's the municipality has the proof because they're doing the appeal. They have to show that it's worth what more than what the assessment is, and it falls outside that corridor. But you also have the right to hire an appraiser and argue that it's not worth that much. Not an enviable position to be in, because at the end of the day, you're just going to hopefully end up where you started. But just be aware that we're seeing that more and more.
And as Tom noted, with respect to this new phenomenon, which we've seen grow in popularity over the last few years, especially in the 3 cities that were listed, we have seen this type of action out in suburbia. I do know that there's one law firm in particular that is pushing this and representing a number of municipalities, actually all 3 of the cities that you saw listed. However, the first one of these I handled was out in Hunterdon County. I had some in suburban towns down in Middlesex County last year. So I think it's something we will see more of going forward throughout the state. Some assessors just, they're adamantly opposed to this practice. There's a lot of opposition, certainly on the part of property owners and their counsel. But even some assessors don't like it because it offends the uniformity clause of the Constitution, where all properties are supposed to be taxed on a uniform basis. Won't get into all the legal issues involved, but these appeals are out there. And I've had clients buy properties while they were under appeal. And in some cases, they didn't realize it. Now, the prior owner is on the hook for those prior years, but it does have an impact going forward. And we're finding more and more we're being asked to consult where we have prospective buyers looking at properties and finding out, this is particularly true with respect to multifamily apartment buildings, as well as industrial warehouse properties, e-commerce facilities, where they're under appeal and the prospective buyer wants to understand what the potential liability is. So it's something to keep an eye on if you are in the market for a commercial property going forward.
Yeah. So it is critical to know when and where to file your appeal. Now, in most counties in the state, including Morris County, the filing deadline is April 1 of the year to be appealed. So it would be April 1, 2020, except if the municipality has undergone a revaluation or reassessment of the entire municipality, then the deadline is May 1. Last year with COVID, the filing deadline was extended for all counties and all municipalities to July 1. I don't think that's going to happen this year. I think these deadlines will apply. Where do you file? Well, you must file, if the property is assessed at exactly $1 million or less, you must file with the County Board of Taxation in the county in which the property is located. So if the property is in Morris County, you have to file at the Morris County Board of Taxation. If the assessment is $1,001 or more, then you can file directly to the New Jersey Tax Court if the assessment is over $1 million. And then that's something you have to decide what you want to do. But you can bypass the county board and go right up to the tax court if you wish, if it's assessed at $1,001 or more. Again, the filing deadlines are strictly construed. What that means is it has to be filed and in the county board offices by April 1st. If you mail it on May 28th and it doesn't get there till April 2nd, you're out of luck. Same thing, it has to be there by May 1. And with the tax court now is online filing, so you have to do it, but it has to be filed by the April 1 or May 1 online. Now the filing deadlines, as you see down at the bottom, there are certain counties that have a different filing deadline. Burlington, Gloucester, and Monmouth are on what's called a pilot program. And there, the county tax board deadline is January 15th. So it's much different. So you have to be aware of that. The tax court deadline, if it's over $1,001, you can go directly to tax court. That deadline is April 1. Even if it's a reval town, it has to go by April 1. So just remember that. But otherwise, it's April 1 and May 1 are the big dates. All right, there are filing fees. County board, it's sliding scale. It ranges from $5 to $150, depending on the assessed value of the property. Tax court, it's $250 for the first lot plus 50 each additional lot. You can join together adjacent lots that are next to each other. Small claims is $50 plus $100 each additional parcel. All residential properties, regardless of how much tax you pay, regardless of what the assessment is, are considered small claims cases. Commercial industrial properties can also be small claims if the prior year's total taxes on that property were less than $25,000. Payment of taxes pending appeal. At the time of the filing of the complaint with the county board or the tax court, all taxes and municipal charges must be paid up to and including the first quarter of each year of that year under appeal. So you have to be paid through the first quarter of 2021, and you have to have all of your taxes and other municipal charges paid prior thereto too. Otherwise, you are subject to being dismissed, and that is also strictly construed. The municipality has to make a motion, but if they make a motion and as of on the return date of that motion, you still owe tax or municipal charges, that you can be dismissed. The municipal charges can include water, sewer, and I live in a little town called Milltown down in Middlesex County. We have our own electric company, and there's a case that says that also counts as a municipal charge since we pay our electric bill directly to the town. All right, I'm going to get into Chapter 91, but just one before that, if you go to the county tax board and you get a judgment and you are not satisfied with that judgment, they don't reduce it or they don't reduce it to what you feel it should have been reduced to, you can file an appeal to the tax court. That appeal must be filed within 45 days of the date of the mailing of the judgment. And they'll have a little thing down at the bottom, the date it was mailed. And so you must file with the tax court within 45 days. Tax court's completely online. You're going to file that online, and you can file within the 45 days. Also, with respect to some of the county tax boards, some of them have online filing for their appeals. Monmouth, Hudson, Burlington, and Union are online. Bergen, I think, just also went online. So slowly but surely, we're getting into the 21st century in terms of how these things are done. So you might want to check before you file. In Morris County, it is not online, so you'd actually have to get it to the county tax board office. You can mail it as long as you have plenty of time to mail it. You can deliver it or whatever. All right, now this is another important thing to bear in mind because this happens long before you may be thinking of filing an appeal. It's called Chapter 91. It's a statute that allows the assessor to mail by certified mail a request for your income and expense information. It's sent out usually the year before you might want to file an appeal. But 2021, the Chapter 91 statute that or request that would be applicable would be one that was sent in 2020. Many times we filed appeals or about to file an appeal, and we would check with the prospective client and say, well, did you get something in the mail asking for income and expense? Oh yeah, I did. Good. What'd you do with it? I threw it in the garbage. Well, if it was sent by certified mail and it was done correctly with the copy of the statute attached, an appeal is filed in 2021, that appeal is going to be dismissed. Because again, the whole purpose of that statute is to allow the assessor to get information that the assessor can then use to come up with an assessment. The assessor may not actually use it. He doesn't have to. As long as he mails it out or she mails it out and it includes a copy of the statute and it's not responded to by the owner or the taxpayer, then the property is subject, the appeal is subject to be dismissed when you file it in the following year. So strictly construed by the courts too. So look out for that. All right, with that, I think that's everything that I'm going to present. I'm going to now turn it over to Rich, who's going to take it the rest of the way. Let me just hold on one second and get out of my, let me get rid of my screen. Okay, Rich. It's over to you.
Okay. Before we continue with the slides, there were a couple of questions. I know we said we were going to take questions at the end, but there was one in particular I thought was important to just highlight. The question was whether the 15% applied to commercial properties as well. Everything that we're talking about applies to commercial properties, residential properties. So the ratio, the corridor, the applicability of the corridor, the 15% corridor, the tax rate, It all applies equally, whether it's a single-family home, condominium, small retail building, or major industrial facility. Everything applies the same across the board. You might see some deviation in the tax rate in some municipalities, depending on fire districts. Some towns have things like special improvement districts where they tack on an additional charge, but the underlying rate, which is derived from the municipal budget, school board budget, and the county budget, applies equally across the board. So everything that we're talking about applies to all properties, regardless of the classification of those properties. So in terms of, why we file, Tom correctly noted earlier that the only issue in a tax appeal is value. How much is the property worth? And we are very clear in that discussion with potential clients when they first call. But of course, the reason they're calling is they feel like they're paying too much in tax. And that's what really ultimately is about, trying to save clients money. And what we've done here is just provide some examples of some appeals we've been involved with over the years. And you can see that there is considerable savings. So the way it works, tax appeals, typically on the commercial side, they take some time to resolve. Very rarely do you see a larger commercial property resolve in a single year. And you will have to file appeals in subsequent years. And oftentimes you'll have 2, 3, sometimes 4. I'm in the middle of trying a case. We started in January of last year, but because of COVID, it's been adjourned, where that appeal goes back to 2009 up through tax year 2020. So actually 2019. So they can take many, many years. Your rights as to those prior years are preserved as long as you filed. And you see here some examples where there are refunds of overpayment of taxes in the 6-figure range. And we've seen refunds in the 7-figure range where it was either a large assessment for many years or a really large assessment for a few years. So your rights are preserved as to those prior years. And these examples show not only the refund amount, but the annual tax savings amount going forward. There is something called the Freeze Act, which provides that if there is a judgment that reduces the assessment, that assessment is frozen for a period of 2 years going forward. Whether that act really means much anymore is debatable for a number of reasons. One, typically assessments don't change year to year anyway. I represented a municipality, Randolph Township, for many years, starting in 2003, the first year after a revaluation. And when I left Randolph in 2010, several years later, I started taking appeals against Randolph, and I went back and looked at some of the appeals I had settled previously, and those settlements, those assessments had not changed well after the Freeze Act years had expired. So you will get savings going forward. As Tom mentioned earlier, we are seeing more and more communities go to an annual reassessment model, and if they are doing that, that unfreezes, or you lose Freeze Act protection in that case, or if you make improvements to the property, the Freeze Act does not apply. And again, the Freeze Act only applies to the assessed value, to the assessment. It doesn't freeze your tax bill going forward. It would only freeze the assessment. And one thing we know about taxes is they go up every year. So your rate will increase, but the assessment will stay the same. So here we have some stories of success, but even this Hanover building, which is one I worked on, they're not huge numbers, but to a small owner-operated facility or a small investment property, a $6,000 annual savings is considerable. And so it's certainly something that's worth looking at from year to year. Even on the residential side, now the Sparta appeal is one I believe Tom handled. I did not handle that, but that refund, that's a big amount. I believe that was a multi-year assessment. Sometimes a residential property can take a few years to resolve for
Right.
various.
Yeah, that was a number of years, Rich, but although the actual annual savings were about $8,000. So it was, that one was.
Okay. And the other three
Overassessed.
are appeals that I handled, and we resolved them that year. So that refund amount was the amount they saved for the various tax years in which those appeals were filed. But the property owners there realized a commensurate savings going forward for at least 2 years, and in all instances, probably several years until the towns revalued. And I know Randolph has since revalued, Morris Township, that was after the revaluation in 2016. And so here again, this is on a residential property, this is considerable savings. And even on a smaller property, it doesn't necessarily need to be $1 million home or an $800,000 home to achieve this kind of savings. We've seen several thousands of dollars of savings for even smaller residential properties. A more modest Cape comes to mind that I had in Morris Township, or a small home, a ranch style home down in, I think it was Garwood, down in Union County. So every property is unique, every assessment is unique, and you should have it. You should do a checkup every few years to see where you stand in terms of the assessment. Of course, the world has changed dramatically in so many ways over the last 10, 11 months because of COVID, and it's had a dramatic effect on all of us, and certainly many professions, some more than others. I was joking before we got on, opened up the seminar to everybody, that I think this is only the third or fourth time I've actually worn a tie since COVID started. We've had a couple here. I've had a couple hearings virtually, but we haven't really been in court, and it's had an impact on the legal practice, certainly. And I can imagine most of you have impacted one way or the other as a result of this. One of the things I want to talk about, it's not on this slide, is the impact that the pandemic has had on landlords. As Tom noted, the issue in a tax appeal, it's all about value. But tax savings is really the key issue. And now more than ever, where you're looking to cut costs, this may be something you want to take a look at. Unfortunately, for larger commercial properties, I think the delays we're seeing, or the closures, the COVID restrictions that have resulted in public buildings being closed, courthouses being closed, will lead to a backlog in the tax court. At the county board level, last year, it was different. There were a bunch of extensions. I'll talk about that in a moment. But most proceedings occurred virtually. There were some counties, including our home county here in Morris, that required us to come in person when they finally held those hearings in, I think that was late September, we had to go in. I represent one Morris County municipality, and we had to appear. So there is an impact, and it will delay, I think, resolution of some of the larger commercial appeals, which, as I mentioned earlier, takes some time even without COVID, a few years. I always tell people, whether it's a small retail building with a few units, rental units, or a larger building, commercial building, maybe a warehouse facility or an office building, at least 2 years. If we get it done before then, they're really happy. But if it takes 2 years, they were informed, and sometimes it can take more. And in certain jurisdictions, I'll let them know this may take several years, which is unfortunate, but it's what we have to deal with. I think that, let me just, one of the things Tom talked about were filing deadlines. We did see deadlines extended last year. We've not heard anything about further extending deadlines this year. There was an amendment to the statute. It was applicable to that year only. So we anticipate that the filing deadlines will remain April 1 and May 1 in revaluation and reassessment towns. This is kind of a duplicative slide. I mentioned this earlier about what's going to happen with these proceedings. You know, I think that getting back to the impact on landlords, it's important to, and maybe some of you are in this situation where you have a property where you have tenants, and you know the impact to landlords may not be direct because it's the impact to their tenants' businesses, right? You have a tremendous impact to restaurants, to service, personal service businesses, salons, nail salons, hair salons, and the like. And when those businesses were closed for several months, I had clients whose tenants were paying rent or trying to pay rent as much as they could. We heard a lot from the governor about the state of emergency and issuing a moratorium on evictions, especially on the residential side. And you know that's all fine and well, and we appreciate the pressures people are under if they lost their job, their inability to pay rent. But for some smaller landlords, this caused tremendous hardship. I had a client that I represented actually in a condemnation, and we sold the property in lieu of condemnation, got a new property, and he moved his business there. And one of the things that made that new property attractive to him was that there was an income stream because there were some apartments upstairs. It was a newer building, newer apartments, nice rents. And that was going to help pay the mortgage on this new property. And we closed the deal with the developer who was buying the property. It was a redevelopment deal in February. And he had to be out by May of last year. And we all know what happened in between. And he was able to make the move, but upon taking title to that new property, when he went to collect rent, there was no rent. And he hasn't collected rent since. You know, and on a small business owner, that is a tremendous impact. There's some talk right now, or more than talk, there's a bill pending in the legislature on the residential side to allow tenants who are behind in their rents. Basically, there's some options to allow them to pay that back rent. And if I recall correctly, the way the bill is drafted, it would give, and this only applies to residential tenants, it would give them the lower rent under one of two scenarios. One, they could pay no more than 10% of their net income, or two, pay it off over 6 months. If you had somebody with a $2,000 a month rent lose their job and not pay for a year, that's $24,000, and you don't need to be a math whiz to figure it out. Option A is going to be far less than option B at about $400 and change in rent, but it would take 5 years to get that back rent paid. And while it's easy to say a large owner of apartment complexes can absorb that, the client I alluded to earlier, even somebody with a small building, maybe with 8 or 10 units, it's not so easy. These are difficult issues that our elected leaders are going to have to wrestle with in Trenton. But from our vantage point, you know, how do we deal with that in terms of the value impact? You know, these properties that are listed on this slide, we've seen absolutely a depreciation in value. And that's important. What's important to understand with commercial properties, the way they are valued, the preferred method in the tax court is through what's known as the income capitalization approach. The court will look at their income, they'll factor in vacancy and collection loss on a stabilized basis. We're not just going to look at what's happening for that particular property, but we're going to look at what the market rents for similar properties, what's going on in the market in terms of vacancy, what are the expenses, and that'll vary depending on the type of lease. And then we capitalize it and we come up with a value. So, last year, while clients were, taking the punch to the gut, so to speak, in the middle of COVID, as Tom told you, the value date was October 1, 2019. So it was easy for towns to say, well, let's wait and see what happens with COVID. And that's not unreasonable for an assessor or a municipality to take that stance. We saw that with the Great Recession several years ago. In 2009, they wanted to wait and see. In 2010, while technically we were out of the recession, real estate values were still being impacted for several years thereafter. I know there was a question about what the court's going to do with this data that's coming about in 2020. Only time will tell. But from a landlord standpoint, and a real estate investment standpoint, one thing we've seen is, not all the news is bad. We're seeing a number of deals still being done, particularly when it comes to multifamily housing. I'm really surprised by that, but we're seeing deals out there, and also for industrial warehouse properties, which are now known as e-commerce facilities, because as we were all quarantining last year and not going to stores, we were getting everything through Amazon and other online providers, and you need a place to store this stuff. And there are a number of warehouse facilities or e-commerce facilities being built throughout the state, and the value that we're seeing is dramatic in terms of the increase. So again, not all the news was bad as a result of what was happening due to COVID, and from a real estate value perspective. So let me get rid of this. Okay. So again, I've really touched upon this already. We're kind of in a wait and see mode. One thing, as we were waiting to come online here before, I got an email from an attorney up in Bergen County, where I had a retail property under appeal, and we've been going back and forth with settlement negotiations, and appeal to them to come down further this year, and because of COVID, and they agreed. And typically you see with these settlements, you might step the assessment down. It makes the refund a little easier to swallow for the municipality, and you get to the client to the right place on a going forward basis. It's not uncommon. And there, I think, not just because it was the number I wanted, it was probably better off for the municipality because, quite frankly, over the next year or so, I don't see it getting better for this particular client. And, as I said earlier, each assessment, each property is unique, and we're going to have to wait and see. But I do think there are assessors out there who are forward-looking, who are going to try to avoid the big refund hit 2022, 2023 by trying to resolve these appeals now for the buildings or the properties that are suffering, most notably retail. Office, it's really going to be interesting to see what happens with the office market. I know we have some appraisers in the audience here, and they could probably speak better to this than I can or Tom can, but we'll have to wait and see. So I think that's about it from my perspective. I don't know, Tony, if we have any questions. I lost my chat room here. So
yeah, there are actually a few questions that were raised, and I'd be happy to direct them to Tom and Rich. I believe you covered the first two. The last question that was raised by one of our attendees is, does the Freeze Act apply in Monmouth County due to the demonstration program in light of Tartavita versus Union Beach? The Freeze Act still apply there?
That is a good question. I know that technically under the pilot program in Monmouth County, there was no freeze for a while because every municipality was reassessing on an ongoing basis. I know some municipalities have actually opted not to do that, again, because of the backlash that was causing, because the property values were actually they were starting to increase. When they started the pilot program, it was shortly after the recession that Rich mentioned, and the assessments weren't really increasing. Then all of a sudden they started increasing, and nothing gets homeowners and voters in a municipality more riled than to see their taxes going up every year. So some municipalities have actually started not to do it, not to do a reassessment every year. But I know some are still doing it. So,
and one thing I would add with respect to that issue, because sometimes we have a settlement where there's a revaluation coming the following year, or maybe 2 years down the road. For example, if everything goes according to plan, the city of Elizabeth will have a revaluation and going on the books in 2023. So, you know, we've advised clients of that as we're talking about settlement now or in defense of reverse appeals. There's no guarantee, but if you have that reval in the foreseeable future, one thing I tell clients is while you don't get the statutory freeze as provided under the law, there's what I'll call the effective freeze, where if when the reval company comes to visit, I tell them, make sure you keep everything related to this appeal, because if we have a settlement, we have the consent and the agreement of the municipal assessor and the municipality to resolve that appeal at a certain value. And the following year, when they're out there doing their inspections and estimates of value, while we do see changes year to year, oftentimes they're not dramatic. You know, it'll go up or down. It should help you get the new assessment at the right level. And the goal would be, as much as I say this against our own self-interest, is to avoid having to go through the appeal process again. If you've just gone through it in 2020, you don't want to have to think about filing another appeal for many years to come. And you know, the reval companies will take that into account. And certainly the assessors will. Oftentimes when there's a revaluation, most municipalities, or the ones that I've represented, and a lot of the ones where I've had appeals, they will have their own appraiser. The revals is company, the revaluations, when it's a formal revaluation, it's done by another company, but they'll have their regular appraiser kind of check on the commercial properties. Most of these appraisers have worked in these municipalities for many years. They know the market inside and out, and they're better suited on the commercial end to deal with it. And you'll see them maybe bring an assessment down a little or up before it goes on the books. So it's important, if you have an appeal, keep the file, know where it is. So when the revaluation folks come out or the assessor comes out for a reassessment, especially if it's a new assessor, we've had a lot of turnover in Morris County the last few years, you can say, hey, I filed an appeal a year ago. Here's what we did. And so maybe that'll help you get the assessment right and avoid having to file an appeal.
So I see, go ahead, Tom.
I'm going to say the reason this is an important issue is because if you get a judgment reducing your assessment, the Freeze Act will freeze it for the next 2 years. There's two things that defeat the freeze. One is there is a significant change in the value of the property, such as you put on an addition or you make major changes to the improvements to the property, or there's a general revaluation. And again, we mentioned, I mentioned at the beginning that more and more municipalities, not just in Monmouth County, but across the state, are starting to do annual reassessments because it's become easier to do that technology-wise. And I know there are some situations arising because people will file appeals, get a reduction, and next year there's no freeze, they got to do it all over again. And that's what the freeze was meant to stop and to avoid. And some of the judges are starting to look at it a little bit more critically, I think. So I think it's in a state of flux, and I think we'll see some more rulings coming down the pike, perhaps, with respect to that situation.
And where you do have protection under the Freeze Act for commercial properties in particular, it's important to keep in mind while any generally improvements to the property would allow the assessor to come in and account for those improvements and reassess. And they're not just adding on the value. So if you have a 1,000 square foot small commercial building and you put a second story on to add office space, they don't just get to increase the assessment for the office space. It's basically a free look to revalue the entire property. What should not trigger an added assessment is if you're doing general tenant fit up, you got a new tenant coming in. The other thing to keep in mind is oftentimes, as with most litigation where there's a settlement, both sides leave a little something on the table. So if you believed your property was worth $1 million and the municipality said it was worth $2 million and you settled the appeal at $1.5 million, and then a year later you make some improvements and the assessor comes back and says, oh, I'm going to invoke the freeze, or you can invoke the freeze in defense, I'm going to increase you. It doesn't mean you should just accept the new assessment. You should still look at it and see where the value lies. So to any assessors out there and municipal officials, please don't take offense. Just don't take the municipal officials at their word that they're doing the right thing. You have a right to look at it. You have a right to consult with a lawyer or an appraiser. You want to make sure you're being taxed fairly. And ultimately, and it's the most important thing as we're winding down here, that's what this is about. Yes, saving money, but you have a constitutional right as well, not to be overly dramatic, to be taxed fairly.
So we got about a minute left and we have to wrap up, but I thought I would ask one question and maybe see if either one of you can give a really quick answer. Someone owns a building, let's say it's a commercial investment. They have a store downstairs, a couple apartments upstairs, and they come to see you and say, I want to file a tax appeal because my retail tenant was a restaurant and they went bankrupt and the doors are closed. And my residential tenants lost their jobs and they can't pay rent. And I have not received a penny of rent in 2020. I want to file an appeal. Isn't my building valueless because it doesn't have any income? How would you answer that and approach it?
I would say real quick, no, it's not valueless. You do have to take it into account. It should reduce the assessment, but you do have to stabilize it as well. That situation is not going to exist forever. You would still be able to sell your property to someone probably at significantly less than you would have sold it before. Rich?
Yeah, as I said before, the assessors are a lot of them have gone through this in the not too distant past with the recession. And I think most of them will make an adjustment, but to reduce the assessment. But of course, the property is not worthless. And as I said before, with commercial properties, really with any property, we're not just looking at your particular experience. The assessor has an obligation, much like we as property owners have a right to be taxed fairly. The assessor has a statutory obligation to assess in a uniform fashion, and we'll need to look at what's happening in the market. So far, a lot of the assessors that I've talked to, both for my property owner clients and the one municipality I represent, they're looking at this, they're anticipating this, they're taking into account what's happened over the last year. And I think that's the smart thing to do. I think for an assessor to have his or her head in the sand and, say, rely on the 2019 data, it's unfortunate. You're going to have to fight with it. But certainly the property is not worthless. What is it worth? What somebody's willing to pay. But we deal in the hypothetical world, and we have to convince the assessor, where the number should come in.
All right, fantastic, thank you. With that, I just do want to say we are at time. I understand that there might be more questions out there. Please make sure if you have further questions, reach out to their contact information right here on the screen. I also posted it in the Facebook comments and it'll be on the Facebook live stream as well. So make sure to reach out if you have any further questions. But thank you so much for this detailed information. I really hope it'll be useful to our members. I really think it will be, especially in times like these. So if that's everything, I'll look forward to seeing everyone on the next webinar, and I hope you have a fantastic day.
Thank you, everybody.
Thank you.
All right. Thanks, everyone. Take care.